We are beginning the webinar now. Dear participants and speakers, a very good afternoon to all of you here at the webinar on the theme of an international perspective, dispute on law governing the arbitration agreement. We are delighted to have you with us to participate in this insightful webinar that is jointly organized by Asian Institute of Alternative Dispute Resolution, AIADR, and Hyderabad Arbitration Center, HSC. I believe that you will gain valuable insights on the arbitration agreement in an international perspective through this webinar. The tentative of the webinar will be as follows. First, we will have the AIADR President, Dr. Professor Sundra Raju, to deliver the welcoming remarks. Following with the welcoming remarks, we will proceed with the panel session that will be moderated by Mr. Patrick Dam. Later, we will end the webinar with a closing remark from the head of HSC, Mr. Shravan Unam. After the webinar, we will be also having a short networking session with our panelists and moderator. Anyone who wishes to connect with the panelists and moderator will feel free to join the session. It is open for all. Without further ado, I would like to welcome the President of AIADR, Dr. Professor Sundra Raju, to give the welcoming remarks.
Thank you, Wanin. Excellencies, esteemed panelists, distinguished guests, ladies and gentlemen, a very warm welcome to the webinar on an international perspective, disputes on the law governing the arbitration. It is my great privilege and honor to welcome you to this webinar, which is jointly organized by the Asian Institute of Alternative Dispute Resolution and the Hyderabad Arbitration Center. The thematic focus of this panel discussion is to explore the different perspectives and experiences pertaining to the law governing the arbitration agreement, both from a common law and civil law system. Parties' consensus by way of an arbitration agreement is now a common provision in most international commercial contracts. As such, the appropriate law governing the arbitration agreement becomes important for the smooth functioning of the arbitration proceedings. Conversely, the choice of an inappropriate law governing the arbitration agreement may lead to difficulties. Although many jurisdictions have adopted UNCITRAL model law, there are still others who have not done so. As such, the interpretation of the law governing the arbitration agreement may vary. Specific perspectives on how the law governing the arbitration agreement and the method to avoid possible pitfalls will surely be beneficial to all. I'm confident, given the expertise of the panelists, and the result of today's discussion will be illuminating. I would take this opportunity to welcome Mr. Patrick Dam, the moderator of the session, and esteemed panelists, Mr. Chakrapani Mishra, Mr. Veera Raghavan Imbavijayan, Ms. Karen Gott, Ms. Leonora Reisenberg, and Mr. Venkat Raghavan for this webinar. On behalf of AIADR, I also like to convey my appreciation to Mr. Ravan Uman, and the head of the Hyderabad Arbitration Center, and Ms. Manisha Uman, the Registrar and Secretary General of the Hyderabad Arbitration Center, for jointly collaborating with AIADR on this webinar. This webinar cannot have come into fruition without your coordination, effort, and contribution. Now, I'd like to actually thank the most important people here, namely the participants who are present today. Please enjoy the webinar, and thank you so much for your support and time. Thank you.
Thank you, Doctor, for the wonderful welcoming remarks. Now I shall pass the time to Mr. Patrick Dam, a Singapore-based German arbitrator, mediator, and attorney at law with more than 20 years professional experience. To start the panel discussion, Mr. Patrick, the floor is yours.
Okay, thank you. Thank you, Chang. Dato, thank you for your welcome remarks. Yes, we have a panel of 5 distinguished presenters today from whom we are going to hear about the law governing the arbitration agreement in various jurisdictions and some other perspectives. As there is only so much that fits into the 75 minutes we have, I would like to ask the panelists to stick to the time frame allotted for their presentation. There will be questions and answers later with more flexibility perhaps, but for now, time, please, is of the essence. Which is why, without further ado, let's hear our first presenter, Mr. Venkat, who will tell us about the jurisdictions of the Gulf Cooperation Council. Venkat, please.
Note. Okay, I hope I am audible.
Yes, you are, sir.
Okay, just give me a second. So you are able to see my screen? Okay. Okay. Good morning, good afternoon, good evening, depending upon where are you. Thank you for the opportunity to be part of this elite panel for the organizers. So since the time is very short, let's get on to the presentation straight away. So today on this topic, I'm going to just talk about the GCC legal system very briefly, various laws applicable to arbitration agreements, especially in an international arbitration scenario. Then what about the arbitration laws of the GCC states? Of course, when I gave the title, I thought I can talk about the laws about the arbitration of the GCC states, and I can have time, but since the time is very short, I would be concentrating mostly on the UAE case laws. Nevertheless, I thought I would just introduce the scenario about the arbitration laws across the states. Then we are very excited that last 2-3 years we have that the new arbitration law has been enacted in UAE. So what are the key provisions regarding the UAE arbitration law with respect to the arbitration agreement? Also, some of the case laws from the apex courts on the subject topic. Then finally, some tips for drafting enforceable arbitration agreement in UAE. That's going to be, I'm trying to wrap up in 15 minutes, hopefully. So it's like a chess clock in an arbitration, looks like. So that's your geography, the GCC states. There are 6 states. So we have the Arab law, which is actually a mixture of Islamic law and a French civil code. So you're all familiar with the French civil code, which is again offshoot of the Roman law, the French Napoleon, and the other one is the German civil code system. So we have the Arab law is actually the mixture of Sharia and the Napoleon code. And the Egyptian civil code is the first Arab law enacted, I think circa 1948. At that time, it was originally enacted. All the GCC states, exception of Saudi Arabia, have civil codes on their own. Oman was the last one to join a few years back. Saudi Arabia follows the Sharia law. So that's the background of the GCC law as such. And we follow the civil law legal system, which is basically a codified legislation. The case law is mostly relevant, so to say. The judges are bound by the code, not on the precedents. So what we commonly see in the common law system, there is no doctrine of precedents, to say. Also, the approach is actually inquisitorial approach as against the adversarial system of the common law. Although these days the international arbitration actually is amalgamation of both the approaches.
Mr. Venkata, sorry to interrupt, but your screen is not scrolling. Could you share the full screen? Oh, we could not see the...
Your screen is not scrolling at all?
Yes, it's not. Would you like the Secretariat to share from our side?
Okay, fine.
Okay. Okay, yes, the Secretariat will share.
I don't know why. So shall I stop sharing? Okay, so how do I pass on to the next slides? Like if at all I want to, okay, this one, okay. So nobody has seen that, looks like, probably. I think let's, if I have to do that again, the time would be lost. So let's stop here. Okay, I would be introducing the legal system of the GCC states, then the various laws applicable to the arbitration agreements, then briefly about the arbitration laws of various GCC states. Then we will talk about the UAE arbitration law, the key provisions regarding the arbitration agreement. Finally, some case laws from the apex courts on the subject topic to summarize tips for drafting enforceable arbitration agreement in UAE. So that's going to be my presentation today. Can we move on? Okay. So, as I said, Arab law is actually a mixture of Islamic law and the French civil code. So, all the GCC states except Saudi Arabia have their own civil codes. The Egyptian civil code is actually the mother of all the civil codes. What happened? The screen is gone again. So, come down, come down. So, please pull the screen presentation mode. It's in the presentation mode only. I don't know. Can you go? Okay. Can you go to the next slide? Okay. The civil law system is basically mostly based on the codified legislation. There are some exceptions here and there, like for example, the French tort law. The case law is mostly irrelevant in most of the cases. So judges are bound by the code rather than the precedents. So we don't have the doctrine of precedents. And we follow the civil law system, follow the inquisitorial approach as against the adversarial system of the common law. Although the international arbitration, we have a combination or amalgamation of both the approaches these days, which we normally see. Next slide, please. Okay. I'm not an expert in Sharia law, and I'm also not familiar with the Arabic language. So what I understand from the Sharia law, basically there is a concept of ADR to say, the mediation conciliation, which is a concept of sulu, they call it. So which basically says that if there is a dispute between the parties, each party waives part of his right for the purpose of getting a final resolution of the conflict or a dispute. So basically the dispute can be negotiated among the parties, or they can also take the help of a third party to adjudicate the dispute. So to say that the arbitration or the ADR is not alien to the concept of Sharia law. Next slide, please. Okay. Coming to the various laws applicable to arbitration, I think this is an important area. So to start with, the law of the contract, that's a substantive law, which is a governing law of the contract, which is quite normally any contract, especially the construction contracts, we specifically mention what is the law which will be governing the contract, which is important for the validity and the interpretation of the contract, parties' obligations, breach of contract, remedies, all these things arise out of the substantive law of the contract. Move on. The next one is the law governing the arbitration. So we call it a lex arbitri, the procedural law of the arbitration. Actually, this is the Korean law. Basically, every country, they have the national laws, which is enacted based on the institutional model law, most of the countries. So we have the law governing the arbitration. So basically, the seat will decide the governing law of the arbitration or the procedural law of the arbitration. So this is very important for conducting of the arbitration, annulment of the awards, challenging the arbitrators, or if you want to have a judicial assistance from the third parties in evidence taking. So there are many things which we come across in an arbitration procedure. We need to have the law governing the arbitration. Next. The third is the law applicable to the arbitration agreement itself. See, generally, this part is not given so much of importance. So normally the law of seat will cover the law applicable to the arbitration agreement itself, but not all the cases. Sometimes it could be, the seat could be different. The law governing the arbitration agreement could be different. So this is the law which would be governing the existence, validity of the arbitration agreement itself. And there is a word of caution here. If your seat of arbitration is different in another jurisdiction other than the governing the law of the contract, which is normally the case in international arbitrations. So failure to specify the law applicable to the arbitration agreement may lead to the inconsistent outcomes in the domestic courts. I don't have much time to talk about this case law. Basically, you can even see that the Kebab versus KFG. Actually, this is a two contracting parties. In this case, actually, the governing law of the contract was English, but the seat was Paris. So please don't disturb the slides. No, you have to go up. Go to the next one, please. 7, slide number 7. 8. Yeah. In this particular case, English courts and the French courts have reached totally opposing judgments, leading to a lot of confusion. Actually, there is another case which was based on which this case was decided, was Enka versus Chub. So when you have a seat is different from a jurisdiction governing the contract, you have to have carefully, you have to draft your arbitration clause. Otherwise, we may have contradicting judgments coming from different jurisdictions. So that's what basically I wanted to highlight at this point of time. Next. Okay. As far as the GCC states are concerned, thankfully, all the states are signatories to the New York Convention. So that means the portability is there. Wherever you have in your arbitration award, you can bring it here to the GCC to get it enforced. So that's not a problem. And also, except the Kuwait, all the states have their own arbitration law enacted as of now. So in fact, as far as UAE is concerned, we have the federal courts, the UAE arbitration law is there. Also we have the Abu Dhabi Global Market as well as the Dubai Financial Center. So we have a DAFC law. Bearing in mind that a lot of things are happening with the DAFC, that DAFC as a arbitration institute has been amalgamated with the DHAC. However, I understand that the DAFC law is still applicable. If someone chooses the DAFC as a seat, still that DAFC arbitration law would be applicable to those arbitration agreements. So that means we have a comprehensive arbitration laws, mostly in line with the UNCITRAL model across all the GCC states. So that's a good thing to have. So can I move the slide, or it's only somebody have to move? Yeah. Coming to the UAE arbitration law, as far as the arbitration agreement is concerned, here there are some specific things you need to understand if you are coming from a common law background. The person who is signing the arbitration agreement have to have a legal capacity, and he has to have, the representative have to have specific authority to arbitrate. That has to be, that's very crucial in this part of the world. Of course, I will be talking about some case laws on that one. And similarly, that arbitration is not permitted on certain matters like public policy, family matters. That's quite common in all jurisdictions. Next one. The form of the arbitration agreement, as again, in accordance with the UNCITRAL model law, it could be a separate agreement or it could be a arbitration clause within the contract. So, 2 more minutes. That's going to be tough with all the technical glitches I had with that. I think I would ask for an extension of time. So maybe at a couple of minutes. Sorry for that. So basically, the arbitration agreement have to be there as either as a separate agreement or part of the contract. Again, if at all we are making a reference to another document containing an arbitration clause, we have to be cautious. Again, I have a case law on that. I'm going to be talking about it in a minute. So we will discuss the case law at the time. We will explain that because I'm running out of time here. Next one, please. Next slide, please. Okay. So again, we have the principle of competence. The tribunal have the authority to rule their own jurisdiction. If that is challenged, it can go to the court, and within 30 days, the court have to decide the challenge. The parties can decide to proceed with arbitration proceedings. If at all they want to do that, then they have to take the cost. There is some provisions on that. Otherwise, they are normally expected to stay until the court gives their verdict as far as the jurisdiction challenges are concerned. Next one. Okay, coming to the case laws, again, very short time is available. So the Court of Cassation is the apex court of Dubai Court of Cassation. Here, actually, it is not just about the arbitration agreement, about the arbitration clause itself. Here, there were actually typical, like in a construction contract, the developer has hired a consultant to do the design, and also he hired a contractor to do the construction. So then there was actually a issue. The developer wants to bring an action against both the parties together in a Dubai courts. The contract between the developer and the consultant had an valid arbitration clause, whereas the contract with the contractor did not have an arbitration clause. So the first instance.
Time is up though.
Okay, so fair enough. So then I'm sorry, I cannot finish. So can I go to the tips and I can finish off with that tips? The last slide. You don't mind? Yeah. Yeah. No. One more. Down. One more down. One more down. You have to say up. One more up. One more slide up. Yeah, please. Next one. Okay. Oh my God. The tips slide starting with the tips. Can you please go to that? Yeah, please. Leave it for a minute. So the arbitration law have to be looked at it carefully, and that authority, special power of attorney may be required. That needs to be looked at it. The substantive laws, seat and procedural laws have to be clearly defined. That's very important. Language of arbitration, number of arbitrators, that's quite common in any arbitration clause. The key thing is avoid external reference to the contract forms like FIDIC and all, because there could be some contradicting decisions coming out of that. Also, to be on the safer side, incorporate the arbitration clause within the signed contract agreement. So that's all I have to say. So if you have any questions, I will take, and probably we will talk later on. Thank you. Thank you.
Yes, thank you, Venkat. Indeed, this is as good a time as any. There will be a Q&A after the whole session. If you have, this is going out to the attendees. If you have any questions, feel free to use the Q&A icon at the bottom of the application to write in your questions. Else we can do so later. Yes, thank you, Venkat. Now Karen is going to take a look at things from a somewhat surveying perspective. Karen, please.
Good morning, good afternoon, good evening to you all, wherever you are. And I think it's still appropriate to say Happy New Year too. I'm going to try and share my screen and control my own slides. That may or may not work, but let's see. And great. Okay, well, I'll speed along as quickly as I can and hopefully just get through the few slides that I've put up today. I'm talking about avoiding disputes and managing disputes, and also just giving a little overview of the common law position. So avoiding disputes, the beginning and perhaps the end of all of this is the arbitration agreement. If you get the arbitration agreement right, you have a very good chance of avoiding disputes. Alternatively, if you get it wrong, or if you leave everything to be decided by other people later in the day after a dispute has arisen, you've got a very good chance of getting it all wrong. So the parties' bespoke contractual arrangements are critically important. And I think that's true whether you're in a civil law or a common law jurisdiction. But I am essentially looking at this from a common law perspective, since that's the one that really I know most about. So first and foremost, the contract. You can be as specific or as unspecific as you wish in the contract, but the advice always is to put everything into the contract, and certainly in terms of choice of law of arbitration agreement. I'm going to look in a minute at some institutional rules, and you'll see when I'm doing that, that some institutional rules actually deal with the law of the arbitration agreement, but a number do not. And that's even in 2021, when obviously we've seen quite a bit of activity in that area of law and a few disputes. So be specific in the contract. The next thing is the institutional rules. Usually the institutional rules say something which will help, even if it only designates somebody or some process to decide how the law of the arbitration agreement is to be settled. And then after that, I'm going to quickly have a look at ad hoc arrangements to supply gaps in the arbitration agreement, including applications to the local courts, which of course is always an option, but never one personally that I'd recommend. So the arbitration agreement. The parties' contract should state the seat of the arbitration. And if you look at most arbitration clause, you will see that it usually does. State the language of the arbitration agreement. And again, if you look at most contracts, you will see that they normally do. It should state the governing law for the arbitration, and you will see that in many cases, it does not. And it should state the law of the substantive contract. And surprisingly, you would think, in a number of cases, it does not. And if it did so, it would be of some help in determining the law of the arbitration agreement, certainly in accordance with English jurisprudence. So depending what the contract itself says, it may just incorporate institutional rules which deal with the law of the arbitration agreement, or we could hope at least make some provision for that law to be ascertained. So looking at institutional rules, and since we are in Hyderabad, I looked at their rules, January 2019. Obviously, for people who use these rules habitually, you'll know a lot more about them than I do. But the Hyderabad arbitration rules has a model international arbitration clause. And in fact, that clause, which you'll see on page 38 of the rules, specifically deals and makes provisions for the parties to insert a provision stating the law of the arbitration agreement. So, as I say, that to me is the first point of reference, and that's a very good provision. So the model clause in the Hyderabad rules is very good, and it's comprehensive and deals with the subject. But also the rules themselves, the request for arbitration, that's RFA, at clause 4.L, and the response at 5.E also deal with procedural aspects of the arbitration. And there's provision there when you make the request for the arbitration or you respond to the request for the arbitration to deal with that procedural matter. And there you can state either what's been agreed, or you can talk about a proposal that you would make in that respect. And I said there, the RFA includes particulars and observations as to, amongst other things, the applicable rules of law. So AIADR rules refers principally to arbitration under the Undertale Rules. I say principally because not exclusively, and you can use the AIADR rules under any rules that you want to refer to, but the reference mostly is to the Undertale Rules. The Undertale Rules are the oldest of the three sets of rules I'm looking at. They were amended in 2013. And the model clause, the model arbitration clause in Undertale Rules identifies the seat, but is silent on the governing law of the arbitration. Clauses 18 and 19 of the Undertale Rules deal with the ascertainment of the seat and the language of the arbitration, but not the governing law of the arbitration. And this is pretty common, and perhaps it's not surprising that it's pretty common in many sets of arbitration rules, because obviously a lot of rules are modeled themselves on the Undertale Rules. I looked at the LCIA rules. These are newer rules, the newest of the three sets of rules, effective from the 1st of October 2020. The model clause, like the Undertale model clause, refers to the seat and the language of the arbitration. The rules request parties to identify procedural agreements or proposals for procedural matters in the request for arbitration and also the response for arbitration. Again, that's pretty common. But the LCIA rules at Article 16.4 stipulates that the law of the arbitration agreement is the law of the seat, unless, and then there are some provisos. I don't think I've got time to go through them, but I just draw them to your attention. And Article 16.5 of LCI rules says, notwithstanding that provision in Article 16.4, the LCI rules shall be interpreted according to English law. So my reading of the LCIA rules is that clause 16.4 would constitute an agreement on the law of the arbitration. So that settles the matter. So that's quite helpful. And perhaps some of the other rules might look at doing something similar. And then in terms of avoiding disputes, what ad hoc arrangements can you make? Well, you can make ad hoc arrangements to supply gaps. And the first thing always is to negotiate. If you've got a gap, you negotiate your way out of it. If you haven't done it at the beginning, do it as soon as a dispute arises, because that can save you some expensive and lengthy litigation. You might empower the tribunal to decide, or the rules themselves, as I say, may have a process which empowers the tribunal to decide the law of the arbitration agreement. You do have the option of making applications to local courts. I say you do, you may have contracted out of it, in which case you've got all kinds of difficulties. But you can apply to the local courts in most common law jurisdictions, and you would apply to the law of a seat if agreed, or once the seat is determined, because of course not every agreement will have determined the seat. That carries time and cost implications. Two British authorities from the Supreme Court in the United Kingdom, which I would suppose would be broadly either binding or at least of great persuasive authority across the common law world. The first is Enker and Chubb, and that was decided in October 2020. And what that said was that disputes about the law governing the arbitration agreement are to be resolved by reference to English common law rules of conflicts. And basically there are two of those. The first is the law expressly or impliedly chosen by the parties. And in some instances, the contract will deal with this, and therefore there will be a choice. Or for example, if you pick the LCIA rules, which I just pointed you out to, I think they'll be taken as a choice, because that will have settled the matter. Or the second principle will be the system of law most closely connected to the arbitration agreement. Now, Enker and Chubb is a decision which runs to about 120 pages in length. And it was remarkable, I thought, how the justices of the Supreme Court wandered around the playing field to decide basically that at the end of the day, where there actually was no agreement about this, you would come back to the law of the seat, which was what everybody thought it before they started. But anyway, this was the process that they went through in summary. To decide if parties had made a choice of law, the court should construe the agreement according to English law as the law of the forum. So they would apply the law of the seat to deciding whether or not the parties had in fact made a choice. And where they had chosen the law to apply to the contract, that's the underlying contract containing the arbitration agreement, that choice generally would apply to the arbitration agreement. So that moved everybody away from the choice of the law of the seat. What the court also decided is that there is no strong presumption that parties by implication choose the law of the seat. And I think this is what came as a bit of a surprise to practitioners, although there's always been that tension. And the justices of the Supreme Court also made reference to clause 4.5 of the 1996 Arbitration Act. So that may, obviously, if arbitration acts differ between jurisdictions, it may prompt a different outcome elsewhere. But since the English Arbitration Act is very much UNTITLE based, it may not. So where no choice of law for the arbitration agreement or the underlying contract has been made, and as I say, you may think that's surprising, but actually that's exactly what happened in Enker and Chubb, which was about a fire in a Russian plant. So there's no choice of law for arbitration agreement or the underlying contract. The court should construe according to the law most closely connected to the arbitration agreement. And here, and indeed generally, that would take us back to the seat. The second case was decided only a few, months ago. And that is Kebab G and Co Food Group. And that was an application to enforce award in England met by an application to refuse recognition and enforcement under the New York Convention. There actually was also an application to set aside the award to the Paris Court of Appeal, because that was the seat of the arbitration. It was an ICC arbitration in Paris. But applying ENCA, the Supreme Court held that there's no prospect of finding KFG a party to the arbitration agreement applying English law principles. The Paris court had said that they were an additional party according to English law, but the English Supreme Court held differently. And so the English Supreme Court, agreeing with the English Court of Appeal, dismissed the appeal, said that there was no arbitration agreement. They did refuse to enforce, and they summarily dismissed the application for enforcement. And that caused some upset because Kebab G was trying to get enforcement and seeking a full trial, but the courts in England said no. It was pretty clear on the law that there was no basis for enforcement. The recognition and enforcement should be refused by reason of invalidity of the arbitration agreement with Coot Food Group. Therefore, it was appropriate to use a summary dismissal. And what the court also said was the principles of identifying applicable law are the same whether the issue is raised before or after an award has been made. In ENCA, the application was before the award was made, and in Kebab G, it was after the award was made. So practical steps to manage a dispute about applicable law: check the contract, check the applicable rules, look at the local law of the seat. These are the steps. These are the things I've just been looking at. In common law jurisdictions, refer to the principles that have been settled by the Supreme Court in ENCA. They are either binding or they're persuasive, as I've said, and generally use ADR before resorting to litigation to avoid the delay and expense of litigation if you possibly can. And concluding, for all jurisdictions, pay attention to the underlying terms of the arbitration agreement. Make sure the law of the arbitration agreement is clear and settled in the contract. That is your best way to avoid a dispute. Secondly, adopt or incorporate institutional rules which provide a default position on choice of law governing the arbitration agreement. That makes complete sense. And if that matter is not settled by the contract or rules, ensure the mechanism for settlement is otherwise clear. Avoid applications to the local courts. You have delay, you have uncertainty of outcome. And agree ADR mechanisms and principles for the management of any dispute. Thank you very much indeed.
Thank you, Karen. Following Karen, Veeraraghavan, who I think is here, yes, he is going to shed light on the evolution of the law governing arbitration from a transactional point of view. Veeraraghavan, please.
Thank you. Thank you, Patrick. Good afternoon. Good evening to all. First of all, I thank Hyderabad Arbitration Center and AIADR for giving this opportunity to share about a very interesting, even though it has been spelled out as transactional, originally it has to be transnational. Anyway, it is going to be highlighting about the transnational view about the law applicable to the arbitration agreement. Coming to the actual agreement, the definition of the particular arbitration agreement or arbitration clause, literally what has been used, I initially would start from the Indian perspective. In Indian perspective, we do have exclusive provision which very clearly, gives an opportunity for the parties to invoke arbitration. And as a refreshing information, what I wanted to share here is that the arbitration agreement, according to Section 7 of the Indian Arbitration Conciliation Act, along with the recent amendments 2015, 2019, and 2021, it clearly mentions that an agreement to arbitrate means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. And if you look on this particular arbitration agreement, it can have a nature of an arbitration clause, or it can be a separate arbitration agreement. It's a very common, which the Indian jurisdiction has adopted from the ancestral model law as well as the arbitration rules. Having said that, the drafting of an arbitration clause or an agreement is predominantly which has to be considered whether it is going to be Indian jurisdiction or whether it is going to be any other jurisdiction. I'm planning to have some 5 to 6 jurisdiction I have just prepared. You can have a good look on those jurisdiction, but evidently whoever or which jurisdiction has adopted the model law in principle for their arbitration legislation, it is quite set clear. And as a common law jurisdiction, we also have some wonderful judgments by the Apex Court, and it has also clarified some issues pertaining to non-availability of certain prerequisite in an arbitration agreement. Having mentioned about this, what is very common, whether it is Indian jurisdiction or any jurisdiction, what is common when it comes to arbitration agreement is simple 5. 1, the arbitration clause or the arbitration agreement should eventually explain about the nature of dispute which shall be referred to arbitration. Secondly, how many arbitrators have to be appointed? The numbers also the parties can agree in the arbitration clause of the agreement. Third, what applicable procedural law would be placed in that arbitration, that also can be agreed in arbitration clause. Whether it is going to be in India, it is very clear that the Arbitration Conciliation Act 1996 shall apply, whatever might be the governing law. Fourthly, when it comes to the seat of the arbitration, when it comes to international arbitration, and for domestic we use the term place.
Apologies to interrupt, Mr. Imbar. Your slides is not scrolling. Would you maybe try?
No, I'm not moving. I'm just in the slide, same slide.
Oh, okay.
Okay. When it comes to the aspect of the place or the seat, it is very clear that the Indian Arbitration and Conciliation Act, particularly in its section 2, subsection 2, has mentioned that the place of the arbitration has to be India. If it is very clear, then there is only option, we can remove this jurisdiction for the applicable procedural law or the governing law to be quite very clear that the Indian Arbitration Conciliation Act would apply for procedures. But for governing law, it is, or the substantive law, it is well set that we are following normally the arbitration agreement or the trade usage which is applicable. These two are quite a replica of the model law principle, particularly Article 28 of the model law. Okay. Moving on, what does the model law says? According to Article 7 of the model law of 1985, the arbitration agreement is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of defined legal relationship, whether contractual or not. An arbitration agreement may be a form of an arbitration clause in the contract or in the form of a separate agreement. It is exactly the Indian jurisdiction has adopted the basic principle which has been given in the model law. Okay. Now moving on to some jurisdiction, I already Karen has touched upon with wonderful case laws. I have just taken this case law, AIADR-HAC versus chub. In this case, the apex court of England and Wales considered the following two situations. One, if the contract does not specify the law governing the arbitration agreement, it is not the arbitration clause, it is mentioning about the contract as such. If the contract is not mentioning about the governing law, but it specifies the law governing the contract, then the law governing the arbitration agreement will be the same as that of the law of the contract. And they also clarify that even if that law is different to the chosen seat of arbitration, that doesn't matter. It is very clear that the law governing the arbitration agreement, if it is not mentioned in the contract, obviously it will be the same as if the law of the contract. This is a well innovative idea what the apex court has given, and it also adds in the absence of both the governing law of the contract and the governing law of the arbitration agreement, that is even worse situation, the arbitration agreement will be governed by the law with which it is most closely connected. And in this case, the seat or the place of arbitration happened to be London. As such, the Supreme Court held that the English law was a law applicable to the arbitration agreement, and that too, it was the law mostly closely connected to the arbitration agreement. This is full of wonderful avenues what has been given as London to be a seat. If we are going to determine London to be a seat, that is the reason why predominantly London happened to be the best venue, and it has to be the global hub for international arbitration, that too institutional arbitration, as Garen was mentioning about LCIA. LCIA rules, which has been updated, also gives a wonderful opportunity for all of us to go to London and arbitrate. Moving on to the French aspect, it is very clear that the French courts have developed the so-called substantive rules of international arbitration law, which allow parties to forego any recourse to conflict of law methods, such as the closest connection principle relied on in the same case law wherein the English court has decided. We can also add, when you look on the French system, the French law will therefore assess the arbitration clause without any reference to the applicable law of the underlying contract. And it also means that the arbitration clause is considered to exist autonomously from the contract. That is somewhat similar to that of the model law. Moving on to Australia. Sorry, I'm rushing because I have only few time. Australia, the Australian court has not specifically considered this issue, and we can say it would primarily seek to give effect to the intention of the parties as evidenced by the agreement and possibly the surrounding circumstance. In effect, this means that where no other governing law is expressed to apply to the arbitration agreement, the governing law of the main contract would ordinarily apply to the arbitration agreement. It is somewhat similar, all the Commonwealth common law jurisdiction as well as the civil law jurisdiction considered to be somewhat similar. But moving on to Singapore, what does Singapore says? Where there is no express choice of governing law of the arbitration agreement, the Singapore courts have recognized that substantive law of the main contract is a starting point in determining the implied choice of law governing the arbitration agreement. And to add, the Singapore courts have held that the governing law of the main contract is a strong indicator of the governing law of the arbitration agreement unless there are indications to the contrary. Whatever jurisdiction you have seen till now, it all goes along with the governing law of the contract. When you look on to the Hong Kong, the current position in Hong Kong regarding the determination of the implied choice of governing law in an arbitration agreement is we have to wait and see. According to the research what I have done, it is quite unclear, and the case law says some case laws have been already under research. We could find that one thing, whilst conflict of law commentary says another. the case law and the commentaries when it comes to conflict law, it differs. Henceforth, we have to wait and see to what extent it is quite in practice when it comes to law applicable of the governing law regarding the arbitration agreement. Moving on to China, we can literally say that the Article 18 of the Law of Republic of China on the choice of law for foreign related civil relationship provides that the parties concerned may choose a law applicable to the arbitral agreement by agreement. Here, in default, if it is absent, the absence of such a choice being made, the laws at the locality of the arbitration institution or the seat of arbitration apply. As of now, in my little understanding and exposures in CTAC arbitrations, in China, predominantly it is considered that institutional arbitrations are recognized and ad hoc arbitrations are illegal. And we might just expect some changes to this also. But it is very clear that the Chinese arbitration law gives an option very clear that the law applicable or the law at the locality of the arbitration institution like China International Economic and Trade Arbitration Commission, CTAC. Then we do have the various subcommissions of CTAC. All these subcommissions are very, very, very clear, and the rules which are applicable is automatically as a default is applicable for China seated arbitration. Moving on to South Africa, I think many of you would have gone through recently there was a bill, international arbitration bill in South Africa, and looking under that South African law, the parties to an international arbitrations are free to agree the law applicable to the arbitration. Whether the parties to an international contract have not agreed on which law applies, the general rule, it is very clear, the general rule of South Africa private international law is to distinguish between the rules of procedural law and the rules of substantive law. It is also somewhat related to Indian jurisdiction. And as a matter of repetition, I'll just highlight where the parties to an international contract have not specifically agreed on which law applies. The general rule of South Africa private international law is to distinguish between the rules of procedural law and the rules of the governing law or the substantive law. Here, some more observation, what I could see is that, however, there is an express choice of law to govern the arbitration agreement. That choice will be effective irrespective of the law applicable to the contract as a whole. It is quite different from the earlier jurisdiction, what we happen to see. If there is no choice of law for the arbitration agreement, but there is an express choice of law to govern the contract as a whole, the arbitration agreement will normally be governed by that law. Ultimately, this also goes to the same pocket that whatever might be the contract governing law, that becomes a default applicability of the governing law. And whether they are going to mention it or not, that doesn't matter. The default is understood. Sorry. The default is understood that we are very clear that it is going to be the law which is mentioned in the contract that becomes the governing law of the arbitration agreement also. Moving on to some other jurisdiction like Spain, the heartland of Europe, the law applicable to an arbitration agreement in Spain is quite regulated by a specific article 9.6 of the Spanish.
Your 15 minutes is up.
Yeah, I'll just try to sum up. Of the Spanish Arbitration Act 60/2003, and it applies a most favorable criteria approach, whereby the agreement will be valid under Spanish law as long as it complies with either the law chosen by the parties to govern the arbitration agreement, the law applicable to the substance of the dispute. Thank you, friends. As a conclusion, I'm also going in line with what Karen was mentioning about the institutional arbitration rules, particularly the ICC, International Chamber of Commerce, and LCIA, which recommends that the seat of the arbitration, the number of arbitrators, the language of the arbitration, and the law, there is a substantive law which governs the contract. This is all well set, and we also expect that the future disputes can also be taken by AIADR in Malaysia, HKAC in India, along with KCR in India. And there are a few other arbitration institutions which are, to this context, given a fullest clarity that the default arbitration agreement, particularly to be governed, is going to be the governing law of the contract. Thank you.
Thanks a lot, Veeraraghavan. This was a very much an overview of so many jurisdictions and legal systems there. After which we now hear Chakrapani on the very much Indian perspective, please.
Thank you, Patrick. I'm sorry. Thank you, Patrick. And greetings, everyone. It's absolute pleasure to be here. Sorry, my voice is a little scratchy today. Pardon me for that. My earlier panelists have already spoken about, or briefly touched about the importance of having a proper seat defined in an arbitration agreement. Today, I'm going to touch upon the aspect of the importance of seat and venue viewed from the 5 important Supreme Court judgments that have come out. And unfortunately, they have not given a very clear picture, and in fact, picture shifts from one side to another. So we will go through that, and each of these judgments, I must confess, may take a full day to discuss as a topic of discussion. However, I'll try and do whatever I can to summarize in a brief time that is available. So, as earlier panelists have mentioned, the seat is not defined under the Indian Arbitration Act. What is used is a word place, which basically translates to the lex arbitri or the seat of arbitration. Now, what happens in a case where the seat is not defined and only the venue is defined? It leads to a lot of complication, and it has been a subject matter of serious discussion and litigation. And as I mentioned, Supreme Court has given various judgments which are somewhat shifting from one side to another. So coming to now, I think we'll skip the next slide and jump straight to the case law. Yeah, so we all are aware of the famous English case of Roger Shashwa versus Mukesh Sharma, where interestingly, the arbitration clause did not mention the seat. It only mentioned the venue. However, the English court decided on that and said that if a seat is clearly mentioned and it is clear from the rest of the clause that parties meant a particular jurisdiction to be the venue for arbitration, given certain conditions, even the venue can be accepted as a seat for arbitration. Now, important thing in that was that the court there decided that it should be a clear indication of venue. It should be that there should be an international governing law. In that case, it was ICC arbitration rules. And it should be that there should be no negative indications that parties did not mean a particular jurisdiction to be the venue. If these conditions were satisfied, then even a venue can be construed as seat of the arbitration. And we all know that it's very important because seat assumes significance, because it also gives jurisdiction to the supervisory court, and it also avoids confusion of multiplicity, because often if a seat is not decided, then parties end up litigating on that. So this Roger Shashwa principle was accepted by our Supreme Court in the famous Balco case, which we all know as Bharat Aluminium versus Casual Aluminium Technical Services. This case in 2012 decided that Rogers-Joshua principle was correct, and it upheld that in situations where seat is not defined and only the venue is mentioned and conditions are satisfied, we should uphold that venue would also be treated as seat. So with that was the principle that governed this position. There was further case which followed, which was no, sorry, the earlier slide, please. This case was also followed, this Bharat Aluminium was also followed by Enercon case, which again held the principle of Rogers-Joshua. And the position continued and, I'm sorry. Sorry. And the position continued, and one would come to think that the legal position was settled and this principle will apply. Next slide, please. Next slide, please. Yeah, thank you. So, no, I think we skipped one slide. We need to go back to 5. Then came in 2019 a case of Hardy Exploration. Now, this case completely deviated from Rogers-Joshua principle, and it said that merely because a particular venue was chosen, in this case it was Kuala Lumpur, it does not mean that it can be interpreted that Kuala Lumpur would become the seat of arbitration. And the inquiry that court held came to a finding, a controversial one, which was much debated, that there has to be additional elements to make a particular venue a seat of arbitration. So this was, as we see, it was a complete deviation from the earlier position, where we had a clear situation that if a venue has been provided and seat is not provided and things are clear, then courts can interpret that venue to be the seat of arbitration as well. However, this was a complete departure from that, and courts refused to apply Rogers-Joshua principle and held that it will not be mere mention of the venue cannot in itself give rise to the fact that it can also be treated as a seat for arbitration. This followed immediately by next important case, which was the BGS Soma. Again, this is a concomitant bench, which again 3 judges bench went back to the earlier position, that is of Rogers-Joshua. And it said that no, the test applied by Rogers-Joshua are correct, and that it should be where position is where venue has been mentioned, then it can be interpreted to have that it can also be treated as seat for arbitration. In fact, there are some comments made with regard to Hardy Exploration in this judgment, where the Supreme Court said that Hardy may not be a good law because it disregarded Balco, which was a 5-judge bench decision. Be that as it may, once again, parties felt that situation has become clearer and it can be safely interpreted that a venue where it is mentioned and seat is not mentioned, one can still go back to the position that the venue can also be treated as seat. However, that was not to be. Next slide, please. Yeah. Now again, the next decision which comes is Mancasto Impex. Now here the court observes that the seat, there was no mention of seat or venue in the arbitration agreement. The court came to the finding, and it's slightly different from the finding of Hardy Oil, but the principle remains the same. The court's inquiry was slightly different, but the decision that court came to, or the finding that court came to, was that it is not safe to conclude that place of arbitration would automatically be the seat of arbitration. And it again went back to the same position that further inquiry is required, ingredients to be examined, ingredients of the arbitration agreement need to be examined to see whether one can safely hold that a venue can be also treated as seat for arbitration. So we again have, it's like going forth, coming back, going forth, and it's again back to square one situation that nothing is clear in terms of whether Rajasasya principle can be upheld or whether Hardy oil would be good law. So next slide, please. So what we see from these judgments is that court has not taken any clear line whether it will go by the Palko or Rajasasya line of judgments, or it will take Hardy oil or Soma JV case. Its position is still unclear, and given the complication that Balco was a 5-judge bench judgment, this position will have to be again cleared by a 5-judge bench as and when it comes. As of now, the fact remains that it will be on each, sorry, somebody says screen is not visible. So fact remains that it will depend on each clause. So the takeaway from this would be that if we are drafting an arbitration clause, as my earlier panelist said, care must be taken to mention that seat of the arbitration is so-and-so, and the venue would be so-and-so, because as we know, venue is just a location, is the seat which has the judicial meaning and judicial implications. So this is in a nutshell, the judicial position with regard to seat and the venue of arbitration. I have concluded this. However, one aspect which I often get queries on, and I thought I will quickly touch upon it, is on the next slide, please, is can two Indian parties choose a foreign seat? So there was some debate on this, and there was no clarity on this part. However, in 2021, the Supreme Court has come up with the decision of PASL Wind Solution versus GE Power Conversion. Now here the court very clearly set out that two Indian parties can choose a foreign arbitral seat, and the parties to such foreign seated arbitration will be able to obtain interim relief from Indian courts as well. So two important takeaways here, that one is that two Indian parties can choose a foreign seat, and that if the clauses permit, they can come to Indian courts and obtain interim relief while the arbitration process is on. So this judgment is important, and I thought I'll just share it with you all. So with this, I have come to an end of my presentation. Happy to take any questions. Thank you, organizers and my co-panelists, for having me here.
Well, thank you very much. Yes, another reminder again, if you have questions, please type them into the Q&A section using the Q&A icon at the bottom of the application. We shall take a look at them later. Yes, thank you, Chakrapani, for your so succinct presentation. And finally, Leonora is going to shine a light on the tribunal and their perspective. Leonora, please.
Thank you, Patrick. Warm greetings to everyone. It is both an honor and a pleasure to be with you today. My thanks and my appreciations go to HAC and AIADR for the generous invitation. My congratulations to both institutions for running this very valuable joint event. I have no doubt that there will be many more on the back of this one. And my thanks also to everyone that is participating today. I am mindful that we have run over time, and I'm very grateful to you for still being online. For those of you that know me, I am a practicing arbitrator based out of Dubai. My practice is international, and I have the benefit of having a global perspective. Today, I thought I would regale you with tales of a tribunal's perspective when considering the law governing the arbitration and the arbitration agreement. And it may be helpful as a starting point to remind that there are several laws that apply to international arbitration. You would have heard about these laws during the course of the panelists' discussions earlier today. But in effect, you've got the law governing the arbitration itself, that's a lex arbitri. You've got the law applicable to the merits of the dispute, that's sometimes referred to as a substantive law or the lex contractus. You've got the law applicable to the arbitration agreement, the law governing parties' capacity to arbitrate, and that's very relevant in a number of jurisdictions. And finally, the law of the place of enforcement of the arbitral award. And we all know that execution doesn't always happen at home. It will largely depend on where the company or the individual and its assets, or his or her assets, are located when you're considering enforcement. And that may well vary. It certainly gets very interesting, and in some cases, rather challenging, to determine which laws apply to what. And as a tribunal, you're often asked to make sense of an arbitration clause that hasn't been drafted as well as it could. No doubt because it's left to the 11th hour, sometimes referred to as the midnight clause. People are exhausted negotiating other terms. They come to dispute resolution and they have very little energy left to argue about anything. So you may find yourself in a situation where there is an arbitration agreement that sets out these laws. And even then, the parties might take different positions to suit their own interests, and you're asked to make a ruling. Or worse, you might find yourself in a situation where the arbitration agreement omits to set out the detail, and the parties still take different positions, and you're asked to make a ruling. The answer is not always straightforward. But we are fortunate to have some guidelines, and I'll take you through some examples. If we consider the lex arbitri, so that's the law governing the arbitration, that's your body of national rules that set the general framework for the conduct of the arbitration. It's often found in the Code of Civil Procedure, certainly if you're in civil law jurisdiction, or it can be housed in a standalone piece of legislation such as an Arbitration Act, more common in common law jurisdictions. And parties may want different procedural laws that they are familiar with, that they're comfortable with, or that might suit their own interest and align up with their own legal strategies. So there is some argument to be had, and there's always some wriggle room. You also need to bear in mind that in some jurisdictions, the local courts that would be supporting any arbitral proceedings may be more accustomed to entertaining and certainly granting applications for interim relief. And certainly applications for interim measures are very popular nowadays. So these are all considerations that the parties might have. Now, I think we all agree, certainly from everything that I have heard today, that it's fairly common for the arbitration agreement, if it sets out the seat of the arbitration, for that seat of arbitration to be taken as a guide to indicate what procedural law would apply. So I've got an example that is very relevant here that I'd like to share with you. So that's one of my war stories. And it involved a shareholder dispute. There were two public shareholding companies, one of them located in India, the other one located in the UAE, both partners. And they agreed to resolve any disputes or differences in arbitration. They have an arbitration agreement, and it's housed in this joint venture agreement that they sign up to. And the arbitration agreement provides for certain things. First of all, it sets out that the agreement, capital A, and the relationship of the parties is to be governed by the federal laws of the UAE, as applied in the Emirates of Dubai. Going further, it sets out that the LCIA rules are to apply. And beyond that, parties decided to go for a neutral seat of arbitration, and they've decided on Singapore. Not uncommon for parties to opt for a neutral seat, and Singapore is as good a seat as any. So when you're faced with this type of arbitration clause, where do you start? What do you look out for? How do you determine what you are dealing with? Well, the starting point and the end point is always the arbitration agreement. So in this particular case, it's quite clear what the applicable substantive law is. That's the UAE law, and that of the Emirate of Dubai. Procedural rules, well, parties decided that they would apply LCIA rules, so that's very clear too. But when it came to the procedural law, the parties did agree on the seat of the arbitration to be Singapore, but both took a very different view. One party, and that was the claimant, said, yes, absolutely, Singaporean law should be the procedural law. The other party, the respondent, decided that shouldn't be the case, that it should be UAE law. You can work out which shareholder was based in what jurisdiction. Now, in this case, Singapore was a seat. And we were helped by the LCI rules, and in particular Article 16.4. And it may be worthwhile just to state what those rules say, and in your own time, feel free to have a look yourself. But what Article 16.4 states is that the law applicable to the arbitration agreement and the arbitration shall be the law applicable to the seat of arbitration. Well, that's very clear. So we would be looking at the law applicable to the seat of arbitration. So if the seat is Singapore, we're looking at Singaporean law governing the procedural law. It does go on then to say, unless and to the extent that the parties have agreed in writing to the application of other laws or rules of law, and such agreement is not prohibited by the law applicable to the arbitration seat. Well, then as a tribunal, you might want to prod a little bit further. And we did look at the definition of the word agreement. So remember that parties agreed for any issues surrounding the agreement and their relationship to be referred to arbitration. An agreement was defined not as the arbitration agreement, but as the joint venture agreement. That was very helpful. There was no separate agreement anywhere, let alone in the arbitration clause, that indicated that parties had instead agreed for the UAE law to be the procedural law. So that left a judicial seat. And that was very much the way that that matter was decided. Another good example, and we did touch upon the place of arbitration as opposed to the seat of arbitration. And this is something that can be quite confusing in some jurisdictions, certainly because of the linguistic differences and differences in translation. And I've had a number of discussions here in the UAE and certainly in the Middle East regarding what place might mean and whether it can be used interchangeably as a seat in the way that we certainly would in the West. And I do have another war story where one of the parties played on linguistic differences and argued that place could mean venue as opposed to seat. And this was regarding an EPC turnkey contract. So it was regarding a storage terminal contract based on the FIDIC Silver Book. One party was based in Guernsey, the other one in Sharjah in the UAE. Party representatives spread a little bit all over, one representative in France and the other one also in the UAE. Now in that case, the arbitration agreement provided that the dispute will be finally settled by arbitration in accordance with the ICC rules. So we're clear that we need to go to arbitration, that we've got ICC rules to have reference to. They're procedural rules. That's not the procedural law. Then it went on to say that the place of the arbitration shall take place in London. And the wording here was slightly ambiguous. The place of the arbitration shall take place in London. And it's based on that ambiguous wording that one of the parties said, well, hang on a minute, we're not talking about the seat here, we're talking about venue. Now, seat may well dictate what the procedural law should be, but the venue certainly doesn't. You can pick and choose where you have your hearings. That should not impact the law of the arbitration. And there were very valid arguments. In this case, we were helped by the fact that the substantive law was also the law of England and Wales. So it brought us back to what appeared to be a natural interpretation that London was indeed the seat, and the procedural law to be applied would be that in England and Wales. So here comes a difficult question. What if you have an arbitration agreement that's not only ambiguous, but beyond that, says nothing about the seat? You are met with complete silence. And a dispute crystallizes, and the moment a dispute crystallizes, it's very rare that parties and party representatives can agree to anything. It's always going to be in the interest of one of the two parties to delay. You might even be faced with guerrilla tactics. Well, in those situations, we also have some guidance available to us. If parties have agreed to certain rules, so in other words, if it's an institutional arbitration as opposed to an ad hoc arbitration, you can always have regard to those rules, assuming that you have submissions that direct you to those rules. So for example, if we look at the ICC rules, we've got Article 14.1, which provides that the place of arbitration shall be fixed by the ICC court unless agreed by the parties. If you've got the LCIA rules, and I would refer to Article 16.1, if parties don't agree to the seat of the arbitration, then the seat will automatically be that of London in the United Kingdom. Unless and until the LCIA court determines in view of all of the circumstances, and after giving parties an opportunity to present their own submissions on the matter, that another seat is more appropriate. So you can go a little bit further than the seat. You can look at all relevant circumstances. And you can imagine just how creative parties can be when they start relying on other circumstances that are relevant. And these are all matters that need to be determined. In ad hoc arbitrations, you could also refer to the model law and the model rules. So if I can start with the rules, I've just seen that I've got 2 minutes left. I'm not far from the end, Patrick, you'll be pleased to hear. But if you look at the rules, and I'm going to be very brief because I am mindful of time, you've got Article 18 that provides guidance. And by all means, do read it in your spare time. I don't think I've got the time to go through it in any amount of detail. They do distinguish between the place and the seat as opposed to the location, so that's very clear. And you also have provisions in the model law. And I would refer to Article 19, which provides the tribunal and the parties with a great deal of power and discretion to determine the procedures of the arbitration. And there is an argument to be had there that modern arbitration practice does allow arbitrators more freedom in choosing applicable procedure, instead of necessarily having to resolve procedural issues in another way. So that takes me to the end of this presentation. I hope I'm within time, Patrick. I would just like to repeat my thanks to everyone. It's been great seeing the number of participants online. I think at one point we exceeded 70 participants, correct me if I'm wrong, but I think that's really wonderful. So thank you to all of you. And thank you once again to the institutions for having us here.
Thank you, Leonora, and thank you all dear panelists. Yes, we have time for some questions and answers, but before we delve into that, let me just say that we will be having a networking session after the webinar, and all of you are invited if you like. There will be a link to join the networking room for that, which will be sent out about 5 minutes before the ending time of this webinar, if you're interested. And with this, yes, okay, let's go for Q&A. We indeed have a few questions, and one of them that has arisen repeatedly is whether the participants may get copies of the slides presented today. I have seen a few replies that AIADR, how about that? Do we have everyone's consent? How do we go about that? Jen, maybe? Okay, in the meantime, the other one was like whether the participants could have the email addresses of all the speakers. May I suggest that you find each speaker, the speaker of your choice on LinkedIn? I believe we are all on LinkedIn. This is a great place to make contact indeed, and I think this will just be the easiest way. Yeah. About the slides, Chang, can you say something about that?
Yes, we can share the slides after the webinar to the participants, to each of their emails.
Okay, cool. Right. Yes, and then we have a few questions that were submitted in the Q&A box. So this is answered. So in the order, Kumar asks, yeah, this is a good one, maybe for Venkat and Chakapani. If an Indian party chooses or can choose the foreign arbitration, then how can we decide on the principle of public policy? Do we do that?
Sure, Mr. Venkat, you want to go first? You are on mute, sir.
Mute. Yes.
Yeah, I think please go ahead, sir, because from Indian context, you have more case laws and you have more experience.
No problem. Feel free to add. But the answer to that is very simple in that sense, because if two Indian parties are arbitrating at a seat which is outside India, the award would still come back as a foreign award, and that will have to be tested under Part 2 of the Arbitration Act. So the question of public policy of India will still have to be, this thing still will be considered before the court, which is going to execute or if, and so on. So I don't see that to be a challenge or a problem. Public policy of India is not being given a go by there. And in any case, on a slight aside, our courts have constantly tried to narrow down the public policy of India, because courts have come to realize that anything and everything gets opened up, any award gets opened up in the name of being contrary to the public policy of India. So those concepts are already getting narrowed down. But to answer the question directly, such award would still be open to scrutiny if a party so wishes. It will come as a foreign award. I hope answers.
Venkat, would you like to add?
Yeah, I think in most of the jurisdictions today, the public policy is being very narrowly interpreted as against the previous bad experiences. We have some harrowing experiences in this part of the world, but those are all things of the past. I think public policy, we don't have to be afraid as such in today's arbitration.
Yeah. Okay. Thank you. Our non-Indian panelists, anything to add, subtract, modify? No, if not, then okay. Then let's go on. Yes, another one for Venkat here. Rajesh thinks that most who draft arbitration agreements may be aware of the significance of the seat of arbitration. Do you feel there's still misunderstandings between place and seat of arbitration? Do these things exist?
Yeah, I think care should be taken while drafting the contract agreement, including an arbitration clause, as people were mentioning, that it's like the last minute people try to draft the dispute resolution clause without proper care. All these kind of problems could arise. I think if you have a checklist and if you make sure that, and most of the arbitration institutions provide a model clause to be included in the contract. I don't see what is so great about writing a proper arbitration clause. So I think people have to be more educated. I think they should come and take more of CR courses to understand at least what is the various nuances of arbitration. I think care to be taken to make sure that we don't have any ambiguity as far as the clause is concerned. Yes, it's better to mention seat rather than the place or venue, because there could be a lot of confusion could arise and the parties won't agree on anything once the dispute arises.
Mm.
Yeah. And I think Ms. Leonora referred to this in her presentation, because it can also be because of linguistic nuances. People may try and take advantage of it. So it's like, it's important to mention it. It's like, it will still be advisable to have a clearer thought on that.
True.
If I may just interject, because they're very valid points. In the first war story that I shared, the shareholder dispute involving the two public shareholding companies, from what I understood, the seat was set at Singapore, but no one really understood what they were doing when they decided to go for that neutral venue. And I think the other point to make here is that you really need to have a think about the consequences and the implications of choosing that seat.
Okay, then let's move on. Hema is asking that, or remarking that even after all procedural matters and after there is an arbitration award, the enforcing of the same is a problem in the domestic country, and domestic courts normally don't approve the same. Karen, would you like to elaborate on that?
Yes, I saw that. That's certainly not the English experience at all. I mean, and I don't think generally in most developed arbitration jurisdictions that's the case. But I mean, we're all signatories to the New York Convention, and certainly the English Commercial Court is very strong and favors greatly recognition enforcement of awards. So in INCA, they didn't enforce the award. That's the exception, not the rule. Really, the rule is in favor of enforcement. And most of these obstacles will be overcome and enforcement will be permitted, certainly by the English courts. And that's my experience in most of the common law world as well. So I didn't really understand that question. I didn't really understand what it could be based on, because just not my experience.
Leonora, gentlemen, any further comments?
No.
Okay. Right, maybe Rajesh is asking something or referring us to a prevailing arbitration in Qatar. Leonora, do you see that in the Q&A box?
I'm looking at it now, but
okay.
by all means, why don't you read out the question so everybody...
Yeah, he refers to the fact that in this particular case, things have taken quite a long time. I think that's what he says. Just to decide whether the termination of the contract was done, took the tribunal 2 years to decide, 2 years, and of course that cost a lot of money. Now they are talking about the entitlement, and it's already been 1.5 years and expecting to go for another 1 year. So, and he calls it a myth that arbitration is cheaper and faster compared to litigation. Would you like to comment on that and maybe, see whether there's the relevance to our subject here, the law governing the arbitration?
Yes, thank you very much. Rajesh Kumar, thank you for the question. It is unfortunate that it's taking that long. I've certainly come across other arbitrations that have dragged on a bit. And there could be a number of factors involved. I wouldn't necessarily say that the fact that it's taking place in Qatar would have anything to do with it. And ultimately, you've got to look at not only the governing laws, the procedural laws, the rules that are being applied, but also party conduct. Sometimes parties, or at least it's in one party's interest, to drag their feet and kick the can down the road, and they do. They try to get away with it. And I would always say, look, you've got to think long and hard when you do draft those arbitration agreements. If you've got a tribunal that's composed of 3 tribunal members, also think long and hard about the tribunal member that you want to nominate. You do need to have a robust tribunal that is not going to take any nonsense and be mindful of the amount of time that it's taking to decide these matters.
Yes, we are discussing this under the headline of under the caption of arbitrator paranoia, right? So where a not so robust tribunal is maybe giving effect to each whim and whimsy of the parties, although that is not always the reasonable thing to do. A certain robustness is certainly not wrong in a tribunal. Yeah. I'm glad, Rajesh, that you said arbitration, the myth is cheaper and faster, that you did not say cheap and fast. Because, yeah, it's of course a bit hypothetical to say what would have happened if this had been litigation, right? How do we know whether a court case would have been faster? Maybe cheaper though. But this may be hard to tell, right?
But there are other advantages of arbitration. A technical dispute, if it goes to the court, they will just appoint an expert, and the expert with the limited time and the resources, they would decide based on their experience, which is going to be totally detrimental to the parties. So they don't have the chance to bring their own experts. So arbitration has, yes, it is expensive sometimes, but it has its own advantages for the parties as compared to the local courts, especially in this part of the world.
Yeah, I'd like to say, just to add to that, I mean, arbitration is a creature of contract. It's what the parties agree. And these procedural spats really do enforce the need for the party to spend time on the arbitration agreement at the beginning and to agree a really comprehensive clause which deals with all these procedural issues. Because as Leonora says, once they're in dispute, everything gets kicked down the road and nothing gets agreed. And we've all got that experience. So if we are in the good position of advising parties at the start, we say to them, you know, get your house in order, agree all these procedural blocks, put them in place. And then arbitration can be faster, probably never cheaper, but I think better for the parties as an experience to resolve their disputes.
Great, yeah. Thanks, Karen. I hope, Rajesh, this answers your question. Or Vikash then asks whether we could please expand on the risks, if any, of having different curial and substantive law. Who would like to do this?
Yeah.
Venkat?
Yeah, I can say that in an international arbitration, it's sometimes you can't have the same law for the substantive law as well as the procedural law for arbitration, provided, for example, if you choose a different seat. See, our experience in this part of the world is like Korean or Chinese contractors, they always want to have a neutral venue. They don't want to have Dubai, DAFC or ADGM kind of a seat. They prefer to have it in Hong Kong or Singapore. So invariably, wherever you have international parties or even joint ventures partners coming from different jurisdictions, they prefer or they perceive that a neutral seat would be preferable. So we can't really avoid having a different procedural law than the substantive law of the contract. So that's a fact of life. So domestic arbitration, yes, you have both the parties within the same country, same substantive law. Perhaps you would be having a similar procedural law of the same country. but in international arbitration, most likely to have the different laws, the Korean law and the procedural law, and the substantive law, because of the very nature of the parties coming from different jurisdictions. That's what I feel. And there is no real risk if it is properly drafted and the parties do a due diligence before entering the contract of looking at the AIADR clause. So what is the seat chosen and how that is going to be beneficial or not beneficial for the party. Think before you ink. That's what I would say. Before getting into the contract, make sure that you make an acceptable dispute resolution clause. I don't see a major risk in that.
Can I add to that? I mean, there's an age-old, I say confusion, I'm not sure that's quite the right word, but there's an age-old difference between what is substantive law and what is procedural law between jurisdictions. And when parties make these different choices, they may end up for something that they didn't bargain for at all. So I think, think before you ink is a great byline, actually. I think it's really important to think before you ink and you put different provisions in. And you can understand why people might say, oh, well, let's go to a neutral venue and have the arbitration there. But actually, you need to explore what the rules, the substantive rules and the procedural rules are in these venues to make sure that you really have a complete procedural code and that it's one that you can live with.
Also, we need to look at that where the parties' assets are located. So that's another thing tomorrow when it comes to enforcement. So perhaps that's also will be a factor to be considered before choosing a seat.
All right, thank you. In connection with Raman's questions, which I'm going to read out next, I would just like to put in Nitin's question first, and very quickly so, because Nitin asks, can we choose different seats and different venues for arbitration? I mean, yeah, Karen. I mean, I would not even have called anyone. So, but Karen, go ahead. Sorry, but unmute yourself, please.
Obviously, yes.
Yeah, right. I mean, there is correctly understood, the arbitration can be made, the seat of the arbitration can be made, for example, the law of India. And if the parties and the tribunal have good reason to meet in Norway as the venue, go ahead, or in Greenland, or in Iceland, or in South Africa. This is the beauty of the distinction between the seat and the venue.
Yeah.
And now leading to Raman's question there, since words such as seat, place, and venue are a source of confusion across jurisdictions, how feasible is it to bring an addendum through UNCITRAL and have it sent out to signatory countries for adoptions in their respective domestic legislations? So addendum, I believe, a clarification on this. Any need for that? Who would like to take this? Leonora? Maybe?
Thank you, Patrick. Before I turn my mind to the question, I would say, if you're going to choose a different venue, choose somewhere nice and warm. So Norway would not be the first place that I would gravitate towards.
It's pretty though, but please all come to Singapore or Malaysia.
That sounds lovely as well. I would also agree with Venkat and Karen about this great tagline, think before you ink. And that really has resonated through my mind every single time that I've heard it today. So it's a great takeaway. But looking at Raman's question here, I can't say that I'm an authority to speak on behalf of UNCITRAL, but would it help to have an addendum in place or perhaps some sort of note that would clarify the confusion? Well, it would. It would certainly make our lives a lot easier when we are looking at these matters. It doesn't necessarily have to be done through UNCITRAL. It may well be that even institutions, arbitral institutions, think about addressing that in their own rules, and I know that a number of them already have.
Okay, thanks, Leonora. Anyone, any additions?
Yes, sorry, if I may quickly, sorry, Karen, after you.
Go ahead.
After you.
Oh, well, sorry, I thought I was talking. Well, I was, but to myself, because I was on mute. The thing about UNCITRAL is it's very slow to change. And I think that's a good thing that it's slow to change, because it's been so widely adopted around the world that if it could be sort of changed on a whim, it would lose a lot of its force. So I agree with Leonora, actually. I think it's something that the institutions could do much more easily, and some of them already have addressed these things.
Yeah.
UNCITRAL may get there eventually, but there are some procedural aspects that UNCITRAL can never get to. And I did wonder when I was looking at the UNCITRAL rules, I thought, well, is this choice of the law governing the arbitration agreement, is this one of those things that UNCITRAL would struggle actually to do, because it may be impacted by different national laws in different places, and therefore it's something that deliberately they've stood back from. I don't know, but I agree with Leonora on this. I think it's something that would be better dealt with and more easily dealt with by the institutions.
Yeah, sorry, if I may add here, I just wanted to advise the person posing the question that just seek good advice. There's no need to get into, like, we can have fundamental discussion about change in policies, but you just need good advice. Take it from a good arbitration practitioner. He or she will be able to guide you to the right way of what is to be done, what is seat, what is venue, what is place. So it's like it can be sorted very easily. Those who know the subject will be able to help very easily. So I don't see it like, as a policy, we need to change anything. Just take advice. Thank you.
Right. I have one for Karen mainly, but then again, not just for Karen. Karen, you said in your presentation that a contract should state the law governing of the arbitration, or governing the arbitration, in addition to stating the law governing the main contract. It said so in one of your slides. Question to you, but actually to all of you, to the extent that you advise as counsel, do you see parties adopting this advice?
I think that perhaps, certainly since Enker and Chubb, they do it more now, because it's very much to the front of their minds. I think historically, in the last 10 or 20 years, they haven't worried about it so much, because quite often they would just link it to the seat. And if you have the LCI rules, although I referred to the 2020 rules, 16.4 is not a new rule, and it's been there a long time. And under the LCIA rules, if you're adopting LCIA rules, you know that if there's nothing said, the law of the arbitration will be deemed to be the law of the seat. And I think a lot of people thought that, more so, although there was always this contention that either it could be the same law as the substantive law of the contract, or it could be the law of the seat. But some institutional rules actually already said it was the law of the seat, so people didn't worry about it too much. But now that they've seen that there can be some quite expensive and protracted disputes about it, they address their minds to it a bit more. And I would certainly advise them to say something about it, unless they said sort of LCIA rules to apply. Then there's the provision. There is an agreement already that can be taken. That is an agreement as to the law to govern the arbitration agreement. But unless you've got arbitration rules that you're adopting that actually deal with it, I would say, for goodness sake, deal with it. It's the same with anything. I mean, I've seen arbitration clauses where they say the parties will agree an arbitrator, and they don't have a default provision as to what will happen if they don't agree an arbitrator. And this has sort of gained some importance now. And so parties really should deal with it in the contract, one way or another.
All right. The others? Because, I have been, as a draftsman of contracts, I've been doing this, including a little sentence in the arbitration clause as to what law governs it. I've been doing that since, I believe, early 2020. and actively. And at first, it occurred to me to be a bit odd. I mean, I have the governing law clause anyway. Then and suddenly I had this rather odd-looking choice of law clause again. Dépassage, for those of us who know, but it is doable. But is it? How does it make you feel? I mean, do you do that? Do you do that yourself actively? Do you draft contracts like that? Any of you?
Normally, wherever there is an international parties involved, in addition to the seat, we try to say the procedural law of arbitration as an additional sentence. The seat would be Singapore. The procedural law would be Singapore arbitration law. So we try to add that wherever we have, because we used to deal with Iranians, various kind of nationalities in this part of the world. So better to make it clear so that there is no any ambiguity as far as the procedural law is concerned, how this is going to be done. So I think whenever there is an international party involved, it's better to spell it out so that you don't have any confusion later on. That's what my experience doesn't harm.
It's better safe than sorry, I think. And otherwise, I mean, you end up with Leonora's position. You know, how on earth do tribunals resolve these issues? And it certainly causes delay and expense while these matters are ironed out. If they are ironed out, and I mean, if they don't, you end up in an anchor and chub position.
In fact, that is the trend that I have seen in last 5 to 7 years, where now clients are more aware and they do ask out, they do consult the arbitration experts in the firm before they sign on the contract. So that is something which I feel is a welcome trend, because earlier it used to be just a 3 a.m. clause which would be cut copy paste from some draft. Now the trend has changed, and clients are more nuanced and they have probably burned their fingers in earlier arbitration. So they are now looking for advice, expert advice before they sign the contract. And I think that's a welcome change.
I agree.
All right. Well, thank you. I look at the time and I'm mindful of the networking session that we can have after this, and maybe it would be a prudent thing to call for a 5-minute break for the speakers and the panelists, and then we can take ourselves to a networking event.
Will there be a separate link or the same link where we are currently in?
I don't know. I will have to ask the host.
It will be another link, but now we will be having a closing speech from Mr. Sravan, the head of HSC first.
Okay.
Thank you so much for the insightful panel discussion by our panelists and moderator. I hope all of you enjoyed the session. Next, I shall invite Mr. Sravan Unam, the head of Hyderabad Arbitration Center, HSC, to give the closing remark.
Thank you.
Thank you, everyone, for taking time out of your busy schedule and participating in this joint webinar that is organized by AIADR and HAC. The panelists have really provided an edifying and informative session to all the attendees, and I would also include myself in that. And I would also like to extend my special gratitude to Datuk Professor Sundar Raju Garu and the entire team of AIADR for collaborating with HAC and organizing this brilliant session. And I would also like to extend my gratitude to all the esteemed members, panelists, Mr. Patrick Dam, Ms. Karen Go, and Mr. Venkat Raghavan for providing such an insightful and enriching session. I would also like to extend my special thanks to Mr. Chakrapani Mishra, Ms. Leonara, and Mr. Inba Vijayan for your association with HAC as members of the Global Advisory Board and readily accepting our request to sparing your valuable time to participate in this webinar. I strongly believe that the entire session and the inputs by all the panelists are invaluable to the practitioners and the professionals. And thank you, Heather, Hema Wan, and other members of AIADR Secretariat for your coordination with us, and also the panelists in organizing things in a timely and a professional manner. I would also like to thank Ms. Manisha and Ms. Tanvi, the team at HAC Secretariat, in handling the tasks assigned to them in coordinating with the AIADR team and also the panelists and making this webinar happen and a success. On behalf of HAC, I once again thank all of you for participating and eagerly look forward to organizing many such educational and informative sessions in the future with AIADR. And I hope we have a good networking session now.
Thank you, Mr. Shravan, for your speech. With that, it marks the end of the webinar session today. Thank you everyone here for the support, and kindly be reminded that we will be also having a networking session with the panelists and moderator after the webinar. The Zoom details will be as shown in the screen. Anyone interested may feel free to join the webinar session. We will wait for another 5 minutes after the webinar for the participants to join in the networking session. Thank you so much and have a nice day ahead. Before we leave the webinar, could we have a picture session with the moderator and the panelists together with Mr. Shravan and Dato' Sundra? One, two, three. Another one. Yes, thank you so much. We will be sharing the networking Zoom link below. You may join into the Zoom link in the chat box for a networking session.